investigation review allocation. We keep on
Yes.
Good afternoon, everyone. Welcome to the hearing. If anyone is here to testify either in opposition or in favor of any of the bills, please be sure to sign up. The sign-in table is right outside this door. Thank you. And if you are handing in any testimony, I'll be pleased to take it. As Lizzie was at the end, we'll be sitting there at the end by the computer. Thank you. We'll be starting this hearing.
You can do that at the end, but you can mention it through your testimony and picture it and a letter from the senior school system.
Good afternoon, ladies and gentlemen. Thank you for attending the public hearing for the Children, Families, and Persons with Disabilities Committee. I am Senator Jen Flanagan, the co-chair of the committee. Alongside me presiding today will be Representative Aaron Dagan, the vice chair on the House side of the committee. We also have with us Representative Hecht. Thank you for being here with us today. We do ask you that when you testify, you limit your testimony to 3 minutes. We do have quite a number of bills here today that we're looking forward to hearing. And we're going to take legislative out of turn, which is customary due to their schedules here in the building. So we're going to, with that, we're going to begin with Representative Ben for you.
Thank you very much, Madam Chair, Vice Chair, and committee members. Thank you for taking me out of order. I'm here to testify on behalf of House Bill 115, which is an act providing for enhanced protection of children and investigation of abuse and neglect allegations. And referring to Chapter 119, Section 51E, there is precise language about unsubstantiated reports of neglect and abuse. And it says that those allegations should be removed if they can't be substantiated, except further down, there's another phrase that says the department may retain this information on unsubstantiated reports forever. And this happens to be something that was added way back in the beginning of 2000. And I have been contacted by some people who were in some kind of a neighborhood feud. And a neighbor reported the person on the other side of the fence as a way of retribution for the feud. There was absolutely no child abuse involved at all. And so what I'm requesting of you is, if there is a report of abuse and it's unsubstantiated, that you cap it at a 5-year period. It really is just so unnecessary to keep it on the books forever against a report that can't even be substantiated. And obviously, if it's never reported again and nothing has happened over that period of time, it's just really, damaging to a family's reputation. And I am told in talking with people in the Department of Children and Families that this kind of thing happens frequently. And it just doesn't seem right to me that we would keep this kind of a really damaging thing against someone indefinitely. So I would ask you if you would look at it. I believe we've sent you a letter, so you will have it on file. But I wanted to come and just tell you of my personal experience with people this has happened to.
No, thank you, Representative. And I think there's also been conversations of whether or not DCF can see that on the record, but not the court proceedings.
That would be
DCF
fine.
would know.
Yeah.
We see this a lot in neighborhood disputes and
Domestic, yes.
We actually have been talking to DCF, and there have been some calls of people riding in the car, talking on their Bluetooth with the child in the car and recording the drugs. So we're getting to the interesting point here. But we do appreciate it, and we'll certainly follow up with you. You may have heard that we're trying to work on the DCF bill.
Yeah, thank you very much. I know how important your work is and how much time and effort you put into it, so I appreciate you taking this into consideration.
Thank you.
Thank you very much.
Next, we'll have testifying Representative Steve Howard and family from his district, I believe.
Thank you very much, Madam Chair and Vice Chair and member of the committee. You're the member of the committee. These are the Alacos from Seekonk, and we call this bill the Shawnee Bill, named after Shawnee here.
See right here, show?
Trying to thank you for coming to Boston today.
Oh, he loved it.
We've had so much snow.
And we did pass out, thank you. We did pass out a picture of Shawnee a few years ago. He was being held at a hospital, waiting for placement, and the hospital was charging $130,000 plus per month while he was waiting for placement. What was it?
Bradley Hospital, it's a psychiatric facility.
And, well, I'll let the Halikos explain the background and a little bit about Shawnee so you understand the full ramifications. Rep. Dykema, thank you for being here.
Yes, well, thank you for having us here. We believe this is such an important bill that needs to be passed. First of all, our experience with our own son, Shawnee, was, as we call, being held captive or hostage, if you would, or held like cattle for 7 months while funding for residential placement was decided. It was already deemed necessary that he needed residential intensified treatment. So that wasn't the issue. The issue was who was going to fund it. So for 7 months, he stayed at Bradley Hospital, not receiving the proper education, not receiving the proper type of residential intensive treatment he needed. And along that way, you see that picture. He's 9 years old in that picture, has autism, does not understand why he cannot come home, does not understand why we have to leave him day after day after day. Could not go to birthday parties, family events, miss Halloween, miss Christmas, missed all the functions. Mr. Howard and I, we finally were able to get the school department in a meeting and get it in the IEP to say, we'll do the residential treatment. We'll put it in his IEP. Okay, so now the school department did that 4 years ago. And it's costing the Seekonk School Department $193,000, $106.85 a year. I thought, we would think by then somebody else, DDS, DMH would have came in and said, okay, we'll help offset that because it's crippling Commonwealth of Massachusetts school departments across the area, this type of funding. Of course, the type of cost that's involved. But they're not. Seekonk is still paying the whole bill. I spent a year advocating for families with special needs, basically have to go into these IEP meetings as the enforcer saying, because their child was deemed necessary for residential, the only way they were going to get into residential is if we got in the IEP meeting, IEP, plan, or the family filed a partial CRAW or full CRAW, meaning giving custody over to the state. Now, once they go over to the state, then the state will fund and get them into residential. In the go ahead.
Can I just back up? How did he end up at the hospital to begin with?
At Bradley?
What happened?
Shawnee's had multiple severe behavioral incidents. I mean, to the point where he was in such a rage at home, he cut the top of his toe off. He amputated. So he was very, very unsafe at home.
So did you call or did the school call?
We had several hospitalizations
Multiple,
over so many years.
Yeah.
So
And we-
as soon as we felt he was being unsafe at home, we would literally just call Bradley Hospital and they would take him back out.
Well, we tried everything before.
Yeah, we
I
did
mean,
all the
you know what I
steps.
mean? As far, and I spent 10 years on the Butler campus as a crisis intervention counselor for a 36-bed unit. So I felt as though I had all the tools to keep my own son safe at home. And I think we probably bought more time than maybe an average family could, but it just got to the point now where he was definitely at safety for himself, for others, for the other children at the home. It's just so sad right now that the system where these kids have to go to an ICBAT, a CBAT program, then a hospitalization program, and it just keeps repeating and repeating until they either become part, it either gets into the IEP or they become part of full custody of the state. So this bill that I wrote up with the help of Stephen Howard and his crew will eliminate that. And we do have support from the superintendent from CCON in full support of this. They feel the hardship of these types of residential placements on their budget. And it's just not fair for the child himself. They're not receiving the proper education, the proper care. I think it's inhumane that a child needs to spend 4, 5, 6 months, even a month in a placement, even after he's been deemed necessary for residential, because nobody can decide who's going to fund it. I think that's horrific. I think that's not the way we should treat anybody, and that's the way our son was treated for 7 months. And I know it's still going on. Today, as we speak, kids are facing this, and that's why.
So, mind you, when he was awaiting placement at Bradley, it was $130,000 per month.
Per
That
month.
Mass Health picked up because our Blue Cross decided not to pay for his, for him to
So
take
instead
it.
of $200 per year, the state was paying out over $100 per month for 7 months. So it basically 3 to almost 4 years payment.
One of the concerns that we've had, and I've been dealing with mental health and social systems for over 10 years, and I've worked in residential with kids that have been on the spectrum back in 2005, is that there was never a home for an agency for them, and that's why the Autism Commission was created, and the work that we did, and the legislature has passed the autism bill in the past couple of years. We're trying to work on getting better services and better treatment for kids, especially ones who can't stay at home, because there are so many parents that aren't like you who would just give up and give their child to the state and not try to fight for them to be still a member of their family legally and emotionally, that we want there to be options. So we are continuing to work on this, and the payment piece of this has been an important part of that, especially fighting with insurance companies. What Mass Health is covering for him, private insurance should be covering. And we have that battle with private insurance all the time, with that and with addiction, of what they want to cover, what they think the best practice is, and what they think the reality should be, but it's not.
Right.
So I commend the efforts that you make to try to keep your son safe, and really the battle that you fought. And we're definitely going to look at this legislation and take a look at how we can fix it with the law that we just passed, and see if there's a way to incorporate it with regulations.
Thank you.
Thank you. That would be
Okay,
good.
great,
Yeah.
thank you.
Yes.
Thank you, Madam Chair. Thank you for being here today, and thank you for fighting with this fight for seems like for a while. Just sort of 2 questions to sort of fill in the gaps in the story. This doesn't necessarily address the funding issue. This just says let's not get into a quagmire where 7 months.
Well, that is actually, there are 2 separate issues, just as you, exactly.
One, what was the reason that you were given that it took 7 months? So if you can summarize that, and then where did he end up? How close is he to you? Because that's one of the issues too. As the secretary, maybe in Hoya we have the services so people can come to, but if you're living in some towns, there's nothing nearby. It's 20 miles away, 30 miles away. Where's your son now? So how close is that to you?
And what was the first question, sir?
What was the
quagmire?
During that 7 months?
Oh, it was funding. It was basically who was going to fund his residential treatment. Basically, all the doctors said he needs intensified residential treatment. So,
So now the school district's paying that.
The
School.
school said they didn't have to pay for it until I looked up something circuit breaker, and we took Stephen and they realized that they had to pay for it.
Yeah, they had to-
But at first they were saying absolutely not.
right.
And DDS was saying they didn't have to pay for it, the school had to, so they
DMH.
just kept battling back and forth, yeah.
So they're battling back, all these agencies are battling back and forth while the person himself is not getting treated. That's just not right.
So it was 7 months.
So it took 7 months. And the other question, he's at Cardinal Cushing Center in Hanover, Mass., which is a great facility. It wasn't our first choice to have him that far away. That's about an hour away from us. Sean also has significant other health ailments. He did have, he almost died with sepsis to the heart. He had open heart surgery. So we wanted to really try to keep him closer to home. But given the time frame, given the fact that they finally said yes, they gave us a list of what we could choose from. And quite frankly, maybe Cardinal Cushing is the best place for him. Even though it is about 50 minutes to an hour away, they do have 24/7 around the clock on the campus.
Nursing, yeah.
Nursing.
Thank you so much for coming here today.
Thanks for having us here.
Thanks for
We
having
enjoyed the
us.
trip.
I hope you enjoyed the State House.
He's tired.
Lots of people did.
He was very excited to be coming up
He
to
was,
Boston to be testifying on behalf of his bill. I want to thank you all for consideration of this, and I think, it just points out an issue that's there when it comes down to, well, 2 issues. We have state agencies who don't want to foot the bill sometimes because it comes out of their budget, but meanwhile, while they're fighting, we have collateral damage being the individual, and I think by placing a time limit of some sort on this, that it sort of pushes them to move in the right direction a lot sooner. And
I can understand there wasn't a place, the place is waiting.
Right, let's go.
thank you.
Yeah, and like you said, there might be already something we can incorporate that's already out there, because obviously it comes, I like the way Steve and his group writ the bill with some type of emergency fund. So, and that's what we were saying basically originally, that, okay, the doctor says you need residential treatment. Within 30 days, that process should begin. The funding, okay, somebody's gonna have to figure that out, but the child has to get taken care of right away. I mean, because he's not,
As long as it's a vet.
exactly, because they're now following his IEP for 7 months, and that's law. So they're out of order in that area,
They don't have you if you didn't follow that.
Exactly. So it's got to get done.
And for the family, I see your brother,
Yeah.
Yeah.
My oldest son.
Affects the whole family.
Yeah, we have a small daughter, a younger daughter as well too. So it does, and we went through it. We don't, I mean, we hear this cliche all the time. We don't want to see another family go through it. We know families are going through it every single day right now. So I think we have the ability to change that with this act.
No, thank you very much.
Thank you.
Thank you. Thank you.
I do want to announce that Representative Beckman and Senator Love here.
Well, say, Shawnee.
We are going to start down the list of bills for the public hearing today. First bill we have is House 80, an act relative to research in the woods of the state. We have Christy Devine from Mad Angels Army. Yeah.
My intent is to be more generic than specific to the bills, because I really think that there's some real problems here that aren't getting solved, and that some of these bills that sound very good won't change what's really happening to these families. I want to ask the panel if you guys are all familiar with the DOJ case relative to the Baby Gordon case. Everybody's got that down. So what I want to first bring to everybody's attention is that that is a classic case of what's happening all across the country. And had the DOJ not selected Massachusetts to take that case and investigate it, then Massachusetts would have forcefully adopted that baby to another family. And from the time that the DOJ came out with that investigation and their recommendations till now, nothing has changed. I'm aware of multiple cases where the exact scenario has been occurring and is occurring. And I don't know that the legislators really understand what's going on in the field. So every bill that you promote that sounds good doesn't really fix anything because of what's going on underneath it before that law can take effect. And if
Are you testifying to this bill, or are you testifying to something else?
I basically wanted to testify on every bill because every bill that sounds good has a reason that underneath it isn't going to change what's really happening. So I'm trying to speak generically on all the bills.
Okay, you have a minute left.
I have a minute left, okay. So I guess what I want to say, if I have to speed talk, is that you guys are constantly searching for ways to fix DCF. It is a problem that has been going on for 20 years. It's going on in every state. They keep, when a child dies and DCF should have caught it, then immediately all eyes go on DCF, and the knee-jerk reaction is give it more money and start taking more kids. We're taking kids that should never be taken. We're putting them into foster care, which is broken, and it can be statistically proven all day long that foster care is not the right place for children. It's not working. It's harming them. The statistics of what happens to foster kids after is an abomination. And when you consider that we're doing that to kids that should never have even been removed from the homes, so I guess I'm going to rapid fire. My theory is that all we're doing is a vicious cycle of perpetuating a system that's destroying children and families. There's something bad that happens, DCF gets bad press, people investigate just that particular situation, and they come up with all these solutions that never ever change anything. We keep refixing something that's broken, and we keep doing it wrong. I do want to bring everybody on this panel's attention to a website, the National Coalition for Child Protection Reform. It is invaluable. They know what they're talking about. They have 20 plus years of experience. If everybody would really look at the information on that site, we could get some real reform, some real fixes. Another place I want to encourage you people to look is at a site called medicalkidnap.com. Now, please don't let the name fool you that it just pertains to medical kidnap, because it pertains to everything that's going on through this whole child welfare system throughout the country. It focuses on Massachusetts cases. It talks about what goes on in the court. It is a window to the atrocities that are being committed by agencies that are supposed to be protecting the children and are failing them. So I don't know if I'll get a chance to speak on specific bills after, or if I'm shut off for the day.
Specific to the bills. You can testify on whatever bills you want when they come up.
So real
If you want a
quickly,
general conversation though, it might be easier to talk to one of our staff who actually deal with the legislation. Because you do understand that in Massachusetts, anybody can file anything. So it's not as if this panel alone is looking to file bills. A lot of these come from our districts.
I guess what I want to say to this panel is it's not so much about the bills. The bills aren't really going to change. If I could speak to another bill real quickly, just as an example.
When it comes up.
Okay, all right. So basically what I'm trying to communicate is I feel like you guys are talking to the wrong people. You can't go to the broken system, a system that systemically is broken and has been for decades, and ask them how to fix it, because if they knew, it would have been fixed already. What you guys need to do is talk to advocates like me who are representing families across the country and know the nuances of what's going on, and it's the same in every state, by the way. And talk to the families and find out what you guys aren't, what's not reaching its way up to you. You don't know that this...
I beg to differ though. We all have constituencies that contact us with families who are involved in DCF. We don't sit in isolated offices talking amongst ourselves about what we should do to DCF and never see it. Many of us have actually been to DCF, have gone out on visits, have met with families, have had films in our offices, have had grandparents in our offices of grandchildren affected by DCF. So to say that we don't hear what happens is not necessarily true. But my suggestion would be is that if you want to talk to us as an advocate, it might be best that we actually have a meeting and talk about the concerns that you have, because if the concerns you have are overarching and not specific to the bills, there won't be that much accomplished. So if you want to meet with myself as the co-chair, the vice chair, the House co-chair, our staffs who are designated with writing the legislation, then you're more than welcome to do that.
Okay,
I would just say the same thing, because this isn't the right forum.
This isn't the right
per se.
forum for that.
Because and I would say that much of what you brought up with, we're not disagreeing with you. I mean, we are all very concerned with what we see. We don't want to be sort of these knee-jerk reactions to when a case hits the headlines. We know, as we said, in our districts constantly.
Right.
So we're not saying that you're wrong in any way. We probably agree upon more than you might imagine. But again, this is just, I would welcome the conversation. This is what we would need you to do, to contact us instead of meetings.
I will pursue it. Should it be the people that I'm looking at right now, like all of you? Are you?
Online, if you look into the Children and Families Committee and all of our contact information.
Okay. And then I just want to say that I do believe you that you're probably talking to pockets of people, whatever. But what I don't understand is why something like the DOJ case, which came out loud and clear last January, a year ago, why nothing has changed. I know of at least three families that the circumstances are identical.
But you're not going to see it overnight. You're not.
Well,
There are lives at stake here, and I can understand your concern, but you're not going to see a light switch just flip and things are going to change like that. But that's something that we can talk about if you want to come into my office.
yeah, well, I just think we need to flick some light switches on things before those children are adopted out to strangers. I think
We
that,
have time for that, but we can talk about that.
all right. Thank you very much.
Seeing no one else testifying on House 880, I see that part closed. House 81, an act relative to Health Disparities Council. Is anyone here to testify for or against House 81? I see that part closed. Next we have House 84, an act to provide a pilot program for loans to families with a child suffering from a terminal illness. Ms. Amai, do you want to testify specifically on that bill? You're the only one who signed up to testify.
That's because the paper was in the wrong place, I apologize.
Okay. We see that part closed. Next, we have House 92, an act relative to the best interest of the children. Anyone here to testify on House 92? Did you sign up?
I didn't.
Okay, come on. You have 3 minutes.
Okay. And I
Just say your
apologize.
name for the record, please.
My name is Lori Souza, and I am for this bill, but I would caution, and I have concern when it comes to DCF being the all-deciding factor as to whether a grandchild or a child is placed in a kin placement, because frequently they are held to standards as a foster home would be. So a grandparent can't sleep on a couch and be a kin placement.
Are you testifying on House
I'm
92
hoping-
or 93?
Well, that was my concern. These
Okay.
were the standards, correct?
This is the best interest of the child. The next one is kinship care to grandparents.
Well, this one spoke language of, in the definition, correct? So my concern, as I said, I'm for it. I think that the standards are good. I would just caution that DCF cannot be the deciding factor as to whether a grandchild, a grandparent gets their grandchild, because the standards they're held to aren't family standards.
Okay.
And it's unfair to grandparents who otherwise would be deemed loving, safe, and able to give the child a permanent home.
Okay.
Thank you.
Thank you very much. Are you going to testify in House 92?
Yes.
Okay. You have 3 minutes.
Again, I'm going to try and learn how to speed talk. I'm adamantly opposed to this bill. Best interest of the child is a slippery slope. It can be misconstrued. It can be misappropriated. I'll use the case of Sandra Bullock. She adopted her recent child from foster care, and you try and tell me any DCF worker that is going to think that a child in the care of Sandra Bullock is not superior than to that of a poor family that has no resources. So this best interest of the child is absolutely, it sounds good, and certainly everything we do in life should be based on the best interest of the child. But to have a law where this subjective term is not well-defined and can be wide open for abuse, I just am adamantly against it. Sandra Bullock's is a perfect example. You understand what I'm saying there. What you will find in DCF and social workers, and you'll even see it in some of their reports, they think poverty is a crime. They can't stand that they literally make deals with parents like, oh, if you sign away your rights, we can put your child over here where they'll have this and this and this. Best interest of the child to a social worker would be to promote that over here they'll get the private schools, these people have more money, they'll have a parent that's a doctor and a lawyer, as opposed to these parents over here. So we're terminating parental rights on best interest of the child because somebody's subjective opinion is their life will be better over here. And at the end of the day, research will show that that child will be very damaged from the trauma of separation from their biological parents. And a lot of these biological parents are rendered powerless because they don't have the resources to fight their termination of parental rights. So I think that I think best interest of the child should just be an ongoing effort, not a law. And what the law should be instead is that everything is based on due process, facts, and evidence. But best interest of the child is a very slippery slope.
Okay, thank you very much. Anyone else who testify on House 92? Seeing that part closed, we have House 93 and after it's been kinship care to grandparents. No one has signed up to testify for that piece of legislation. Ma'am?
Do I have to state my name again? Thank you. I just wanted to say that I am in support of this bill, and any change in our legislature that enables and empowers our grandparents of the Commonwealth is good. There's a lot of grandparents who are struggling. Thank you.
Thank you very much. Could you just say your name, please?
Yes, my name's Deborah Gravel. And I've been fighting for custody of my granddaughter who's in DCF care for 2.5 years now.
Okay.
And I just feel that grandparents are always a child's second bond. That traditionally, whenever anything happened, that a parent was unable or unwilling to care for the child, that a grandparent has always stepped in. That it's sad that we even have to discuss this. And I've been fighting very hard for my granddaughter. I've spent tens of thousands of dollars on attorney fees, working 2 jobs to have her placed with me, and instead she's placed in a foster home with strangers. And that shouldn't be happening.
Do you have visitation with your granddaughter?
I will see her tomorrow. I see her 1 hour a month. She's 2.5. We've missed every milestone. Today was her first haircut. Another thing we've missed every holiday. My daughter's rights are being terminated because she has cognitive delays and they have concerns of her ability to parent. At the same time, they have made no provision for services for a parent with learning disabilities. When they changed the goal to adoption, the only service she'd ever had was a parenting class, which was actually, she went and saw a couple movies and that was it. And then they changed the goal to adoption. And we have tried everything to get her placed with family. From the very onset of the case, we had a family from my church who had fostered, that we'd known for 25 years, who came forward to have her placed with them, and they wouldn't even return their calls. We found that the department goes out of their way to deny kinship placement because they get the Title IV-E funding. They get a bonus for every child that's adopted out, but only when they're adopted to strangers. So I'm talking to grandparents all over the country that are going through this, and they're being turned down for the most ridiculous of reasons. I've heard of grandparents being turned down because Grandpa got a speeding ticket 10 years ago, and he just might endanger the lives of these children by speeding with them in the car. But they don't screen the people they place them with as much as they do us. I'm now going through a psych eval and parenting assessment to have my granddaughter placed with me. The pre-adoptive families don't have to do that. And when I hired my own privately, they put a stop to it and said I have to use their vendor agencies only. Thank you.
Thank you very much. Representative Harrington, do you wish to testify?
Yes, I am.
On your legislation?
Yes, thank you, Madam Chair. Thank you, Madam Chairwoman and this honorable committee. I appreciate the opportunity to be heard on my bill, House 92. Although I say it's my bill, it's not my bill. It's the work of a lot of people that are very supportive of this concept. What I'd like to say as a preface to what I'm going to say is that this bill was created actually after an intensive investigation by the House Post Audit and Oversight Committee. Based upon several hearings, it came to our attention that, in fact, our standard for our care and protection cases here in the Commonwealth was not the best interest of the child as it is more so in our family law courts, our probate and family law, as well as in many other states. As I looked to revise the standard here in the Commonwealth of Massachusetts, I looked at various states throughout the nation, and I tried to take what I believe to be the best of the best as we look at our statute and how we may better care for our most vulnerable children here in the Commonwealth. And I'd like to just read to you the preface, and I don't take any right of ownership to this language, as I did get it from another state. I believe I got it from the state of Arkansas. But it says, whereas this legislature recognizes that children are defenseless and that there is no greater moral obligation upon this legislature than to provide for the care and protection of our children, and that our child welfare system needs to be strengthened by establishing a clear policy of the Commonwealth that the best interests of the child shall be paramount and shall have precedence at every stage of court proceedings. Our statute, as it stands presently, says that our first and foremost goal is to strengthen the family unit. Some people refer to this as the reunification standard. And although reunification may, in more than 90% of the cases, be in the best interest of the child, it should not be our end game. Before anything else is considered, the rights of that child to have adults that are caring for them act in their best interest should be absolutely paramount. I've heard over the last year or so from several people that my bill may in fact infringe upon a parent's rights over their child. To that I would say that we have established here in the United States of America, as far back as the mid-1860s, that no human being has a property right over another human being. Children are not property, and children are defenseless, and we are tasked with their protection. What my bill does is it still recommends that we reunify families and do every single thing that we can to strengthen family units by making resources available, but with the understanding, again, that our priority is the best interest of the child. Shortly after our investigation in the House Post Audit and Oversight, at the request of Governor Patrick, the Child Welfare League of America was also asked to weigh in on what we could do to make our situation better. In their recommendations, they said that the central tenets of the CWLA National Blueprint are that children's rights are human rights, that it is the right of each child to have decisions made in his or her best interest, and that it is the responsibility of all members of society to uphold the rights of children. An artificial dilemma is created by considering family preservation and child protection to be on opposite sides of the pendulum swing. Both family preservation and child protection are necessary, and any decisions about either should be driven first and foremost by each child's right to have decisions made in his or her best interest. They go on in their recommendations to further solidify their position that the best interest of the child should in fact be the standard here in the Commonwealth as it is in so many other states. This past year, our governor took on, along with the Lieutenant Governor, the issues that are plaguing our DCF system. In doing so, Governor Baker and his administration has pledged to reform, and in doing so has articulated that we always look at the best interest of the child. I ask that we take the recommendations of our governor's administration, the recommendations of the Child Welfare League of America, and also our duty, uphold our duty to these defenseless children. We've seen time and time again that reunification with an unfit parent has not been in the best interest of our children. And I respectfully ask that this committee report this bill out favorably this session. And thank you.
Any questions, Representative?
Thank you, Madam Chair. And I just want to thank the representative for filing this bill. I know we worked together a little bit on it. My interest in it has been generated by two situations with my constituents, as you know. It really comes down to what you were talking about that 10%. The standards should be very high, obviously, for removing a child from their biological parents. But in certain circumstances, and in the particular cases of my two constituents, you look at these situations and you cannot imagine how staying in that household is in anyone's long-term interest, especially that child. And the standard is so inflexible in that regard. We really do need to take another look at it. Again, I want to thank you for your work.
Thank you, Representative Dykema. And to that, if I would also like to say, a year ago I testified on the same bill as it was presented in the 188th session before the Joint Committee on the Judiciary. And at that time, there was a woman there who testified with me that had been a pre-adoptive parent and had really been sort of dragged over the coals with regard to the possibility of reunification with a mother that had presented with a substantial heroin addiction, had neglected the child, had not fulfilled her contract with Department of Children and Families. The good news was that that woman was given custody of that child through an adoption at some point last year. The bad news is the mother from whom the child had been taken had again found herself pregnant, had the child was allowed to stay with the biological mother, and the child passed away within its first year of life. I don't know all of the reasons that it passed away within its first year of life, but what I do know is that we, as a legislature, have a duty to make sure that those kids are not put back in those dangerous situations and that we're looking out for their best interest, because without us looking after it, I don't know who else will be. So. Thank you.
Next up, we have House Bill 100, an act relative to mandated reporters. No one has decided to testify in favor or against this legislation, so we have that part closed. Next, we have House 112, an act protecting the Department of Children and Family Social Workers' home addresses. No one is decided to testify for this legislation. We have House 115, an act providing for enhanced protection of children and investigation of abuse and neglect allegations. Again, no one has signed up to testify. We have that part closed. House 122, an act to establish a changing and termination standard for the Department of Children and Families. No one has signed up to testify, so that part is closed. We have House 123, an act to establish an independent ombudsman office external of the Department of Children and Families. We have Lori Souza, who's signed up to testify.
Thank you for again hearing me. Families that become involved with the Department of Children and Families frequently have conflict. However, beyond conflict is issues of policy, practice, and procedure, and they need a place to go and have those issues looked at. So there is an ombudsman. However, the ombudsman is currently enmeshed within the DCF office, within the DCF structure, and they have no power. So I am in favor of this bill, moving the ombudsman out of DCF to a neutral, as the bill states, a neutral party, as well as neutral authority up and down, so that they may make determinations and have power to change, to discipline, And along with that, I would like to see family advocates added. The CWLA report did report favorably on the family liaisons. And again, the family liaisons are great. They're very important. Families feel that they have a voice, but again, no power. Nothing changes, no matter the determination. So I would implore you to please report this out favorably. This session,
Thank you very much. Next we have House 130.
Can I speak on that?
Sure.
I too would like to see this bill reported out favorably. I just want to take this opportunity to say that as an advocate for families across the country, I have yet to know of one ombudsman's office in the entire country that actually does its job and helps these families. And I assume you're aware that they recently have cut out some of the family liaisons, whatever. That is, at this current state, a family's only hope to try and get justice in this system. They're railroaded from the time DCF comes into their life. DCF controls the narrative and everything that goes on. And those parent liaisons are the only hope they have of having a voice. And yes, those voices from the parent liaisons need to be given some teeth. So yes, please separate the ombudsman's office, but please make it mean something. Make the ombudsman's office have the power to discipline, report, and do things when we can show that wrongs have occurred to these families. Give them the teeth to effect change, please.
Thank you very much. Next up, we have House 132, an act relative to mandated reporters. No one has signed up to testify. Next up, we have House 3945, an act regarding group care facility. We have a panel, I believe. Jim, you bring somebody. Jim Major and Maureen Brenner. Good afternoon.
Good afternoon. My name is Jim Major. I'm the Executive Director of the Massachusetts Association of 766 Approved Private Schools. Thank you, Madam Chair, for the opportunity to testify today on House 3945, an act relative to the licensing of group care facilities by the Department of Early Education and Care. The Mass Association of 766 Approved Private Schools represents the private special ed facilities approved by the Department of Education to educate some of the Commonwealth's most challenged students and children. We have 87 member schools that operate about 150 approved programs. Those are all approved by the Department of Elementary and Secondary Education, but about 50 of them are residential programs. That are, and that residential portion has to be approved by the Department of Early Education and Care. Now, as you know, Chapter 766 provides special education or entitlement to special ed for children up to through the age of 22 or until they get a high school diploma. However, ambiguities in EEC's authorizing statute chapter 15D have created a situation where EEC has not been, feels that they don't have the authority to license any program, any residential program that's approved under chapter 766, but only serves students age 18 to 22. I'm sure many of you have heard the need for a renewed emphasis on and focus on helping special education students transition to adulthood. We provide a lot of attention and care for them up through their public education years, and then when they transition to adulthood, many times they're not ready, and they have negative experiences as a result of that. Some of our members have been developing programs specifically targeted for the 18 to 22-year-old group But EEC feels that they don't have the ability to license those programs. So it's created a very strange situation in which some of our members have been forced to include students younger than that, 17, 16-year-olds in those programs, which is inappropriate. Or some of them have been forced to close the programs and not meet the need that's there. The bill that we have filed would make it clear that the responsibility of EEC is indeed to license group care facilities for students all the way up through the age of 22. I have with me today Maureen Brenner, who is the executive director of the Riverview School in Sandwich, and she would like to give you some very specific examples of what our concern is.
Thank you, and thank you for this opportunity and all the work you do on behalf of children and families. Riverview's been around since 1957, and we actually had the first license in the Commonwealth to run a special ed program for children with special needs. And we're approved, as Jim said, by DESE, clearly up until age 22, and by EEC up until 17, but 17 to 22 if there are younger students in with them. So the school educates kids with autism, with developmental delays, language learning disorders, Down syndrome, and so forth. We have 200 students, 117 are from the Commonwealth, and kids come from other states and other countries as well. So the issue with the lack of clarity in EEC's language pertains not to our high school program, that's fine, but it pertains to our post-secondary program. We call it GROW, Getting Ready for the Outside World. And we're working on all those skills with our students that will ensure that when they leave us and they age out of the Chapter 766 system at age 22, they will live much more independently than if they didn't have this experience with job coaching, with classes tailored to independent living, with cooking, with meal planning, with travel training, all of these kinds of things we're doing. So we have about 105 students in this GROW, Getting Ready for the Outside World program. We don't have 17-year-olds because typically kids with developmental delays have been kept back in school. So by the time they get into that program, they're already 18. That's just the way it is. We house a lot of these students on our main campus. However, we don't have sufficient beds on our main campus for all our students. And the school has owned properties 10 miles away in Hyannis and have used them since the 1980s to house students who are older. That works out really well. Kids can be more independent. They can walk to jobs. They can plan their recreation. They can attend classes, voluntary classes at the community college, but they have a much more independent experience there. So right now, because of EEC's discomfort with the language in their enabling statute, they're not willing to approve those programs for us anymore. And so we are limited in the number of Commonwealth students we are able to enroll in our program. Two very quick examples of how helpful it is to our students to be able to live off campus. A student, Taylor, who came to us during her high school years, felt very insecure, not able to do anything, compared herself to her siblings who didn't have any special needs. We worked with her. She developed confidence. In her final years with the school in this GROW program, she was in the community. She volunteered at a daycare. She volunteered in our middle school program. She took lessons to get her driver's license. And now, because of that experience, she's got a full-paying job and is taking care of her own needs and paying her own way and is not requiring any kind of state support. We have another young man right now from the Commonwealth who is desperate to have the same experience, coming to terms with the fact that his disability is going to be with him for life, but also recognizing that he's got a lot of independence thanks to this program. He desperately wants to live off campus. We have the beds, we have the opportunities. He's got a volunteer job at Cape Cod Hospital, but unfortunately, because of this confusion within the legislation that EEC has to go by, he's not able to live in this residence. So we're failing to give kids from the Commonwealth opportunities that we know would benefit them and would actually make them much more independent. So we hope you'll support this.
Thank you very much. Thank you for the work that you do. I know the kids that I used to work with went to Iraq, and they thrived. And really, if it wasn't for that, sometimes I wonder if they would have made it to the public school system.
Right.
So I appreciate the work that you do.
Thank you. Thank you.
Any questions, Representative?
So echo the thanks for the work you do. I know Meyer, Partial Music Academy, and other
Yes.
schools are doing very similar work. So just as I'm trying to keep up with all this, is this a recent change that then, a change when we try to fix something and then, oops, this was an unforeseen circumstance, and EDC doesn't want to do these accreditations anymore, or did they before? And then how are any of these programs getting certified now, or are they not at all?
They've certified the programs in the past, but because of the language and confusion that's been raised for them, they're just not willing to continue to approve programs. They're not on a campus with younger children. So the remedy would be to put a 15 or 16-year-old in with 21-year-olds, but we don't do that for typically developing
So
children.
it's not a change in language,
No.
it's just a change in what we've come to. Agencies have realized 18 to 22, we need to actually focus on different programming. And so in doing that, which is the right thing to do, oops, this group doesn't want to certify them.
Right. So this will resolve it for other schools as well. Yeah.
And we, speaking of other schools, we have a letter for you from the Cotting School in Lexington. Wonderful program. They developed a program very similar called Hope House, which has been approved by EEC, but only they've made it very clear that they're going to not extend the approval. And they'll be forced to close that program.
Thank you, Madam Chair. And thank you for the great services that you obviously provide to those that use them. My question is more of a technical one, and given that your program is 18 to 22, I just would love your opinion as to whether early education and care is really the appropriate agency to be making those kind of decisions, given that's probably not the programming that's kind of in their usual type of programs that they look at. Maybe is there an alternative agency that might be better equipped to do that?
There really isn't. We've looked into that to see if there was another agency, and there isn't any other agency that would be able to do it.
Thank you very much.
Thank you.
Next up, we have Senate 77, an act establishing a task force relative to the Commonwealth's directory workforce. Seeing someone plan to testify, we will close that part of the hearing. Senate 96, an act relative to the well-being of children. No one has signed to testify, so we'll close that part of the hearing. Senate 97, an act relative to mandated reporters. Seeing no one has signed to testify, we'll close that part of the hearing. And finally, we have Senate 107, an act to promote employment. Naomi Meyer and Melanie Now.
And if we may, we'd like to add Deborah Harris, who's on there separately to our little panel. Thank you.
We're so busy today.
No stranger to us.
Okay. Thank you so much. My name is Naomi Meyer. I'm a senior attorney in the Welfare Law Unit at Greater Boston Legal Services. And I appreciate the opportunity to testify in favor of Senate Bill 107 on behalf of our clients. In our daily work in the Welfare Law Unit, we see that very low-income parents in the Commonwealth are really struggling to acquire the skills that they need in order to successfully enter the workforce and be able to support their families. And so I'd like to just briefly outline what the provisions of this bill are that would try to address that. But before I do, I'd like to preface my remarks by noting how deeply concerned my colleagues and I are about the ongoing erosion of the safety net for the Commonwealth's poorest families that we see taking place. I'm sure that this committee is aware that there has not been any increase to the no cost of living adjustment to the TAFDC cash grant for very poor families in 15 years, so that the value of that is enormously eroded and is only a small fraction of the federal poverty level. We're also deeply concerned about Governor Baker's recent proposal to cut TAFDC to 8,500 families in which a household member is so disabled that they receive SSI benefits. We also have a number of concerns about proposals of how the administration is going to be implementing the remaining elements of the 2014 welfare bill. So with all of that said, I know that there are other fora where we will be continuing to try to raise those issues, but I wanted to make clear that Senate Bill 107, while we strongly support it, does not address all of those concerns. What it does do is take some modest, common sense steps without requiring new funding to try to improve TFDC recipients' access to existing education and training programs and ensure that they have a reasonable amount of time to try to complete those programs so that they can move forward. So very briefly, Section 1 of the bill would require the Department of Transitional Assistance to provide TFDC recipients with information about available education and training opportunities, including not just the existence and costs, but information that they really need to know about the type, availability, and typical work schedules of jobs that might actually come out of these trainings. Sections 2 and 5 of the bill would allow parents to count basic education or vocational programs to meet the TFDC work requirement for up to 24 months and allow DTA to extend this period if the parent is making substantial progress. This is the kind of skills preparation that families really need. The 2014 welfare law authorized 24 months and possible extensions for people in college programs, but could be interpreted to not allow that for people who aren't even in college yet and obviously need time to get through their high set or whatever pre-college level it is they're trying to complete. Section 3 of the bill would require DTA to screen TFDC recipients to identify their skills and barriers in order to ensure that the education and training referrals that they get really are appropriate for that individual. And Section 4 would make some additions to the list of criteria that DTA considers when deciding whether to grant an extension of time in receiving TFDC, so that it better addresses the realities of family circumstances and the job market. So in addition to the current factors that are already considered, DTA would be required to look at whether the parent had ever been provided with the education and training opportunities that they needed while they were receiving cash assistance, to consider what types of barriers the family is facing at that time to moving forward towards employment, to consider the availability of childcare and other sort of common sense things to ensure that families will not be cut off precipitously. Thank you very much. I will turn it over to my colleague, Melanie Mallard.
Hi, I'm Melanie Mallard. I am managing attorney of the Welfare Law Unit and have worked there a very, very long time, representing hundreds of welfare recipients, both individually and through other forms of advocacy. Our clients range from having elementary school level reading levels to almost finishing high school, but not quite because of what happens in their life. And some of them have some post-secondary education, but often quite outdated. There are many folks on welfare who are further along. The ones we see who need us the most have significant barriers to employment. Those are the educational barriers. Most of our clients, very, very many of our clients have had a traumatic experience, usually domestic violence, sometimes childhood abuse, sometimes other devastating circumstances in their life. Some are able to move forward and some need supports along the way. A number of our clients, a significant factor for them is they don't have any family supports. There are situations in which one of the reasons the client's on welfare is a bad family situation and they have no supports. They may be isolated in the community. Also, so many of our clients are either presently homeless or have had spells of homelessness. Bottom line is a one-size-all approach doesn't work for helping people move out of poverty through employment. People are at very different stages when they arrive on TFDC, and the problem with whatever levels of assessment DTA has been able to do intermittently and not completely consistently is it isn't really matched up with a full consideration of all the non-educational barriers, and it isn't matched up with what the programs that are available really can do for them and which ones apply to them. Currently, my understanding from a presentation in the central office is 1 or 2 workers in each office are charged with finding out about programs in their local area, but there's no coordination to assure that all the adult ed programs, the community college programs, including some that are non-degree programs, the various forms of job training programs, those resources aren't fully documented anywhere in one place. And from client after client I've spoken with, the vast majority, the kind of program they need was never offered to them, never mentioned to them, they were given no information about it. I'm going to be submitting by email my testimony, which includes examples from a few of my clients, and I just want to mention one now. Not a real name. Ms. Green started getting welfare when she had to leave her job because of a health issue for which she eventually needed surgery. She was in excruciating pain. She's actually, unlike most of our clients, she had a high school diploma, and you know that it's consistently through the time I've been practicing in welfare, the data is a little less than half of recipients even have a high school diploma. She worked many, but she didn't have further training or education. So she worked in the low-wage job market off and on. And actually the main reason she lost the jobs after various spells was because her daughter had a health issue, and when her daughter was sick, she would have to leave work, and ultimately she'd be fired for absenteeism. She went to, after she had the surgery, she asked her worker about whether there are any programs, and wasn't given any information about programs that might give her actual vocational skills. She was sent to a career center for job search, not to find a program, but for job search. She went to countless job fairs through the career center, interviews to no avail. And then she happened to hear of a free Microsoft training program at a career center across the river. She lives in Boston, and this was at the one located in Cambridge. It was very fortunate for her. She got into it, she took it, and then through that career center, she did happen to learn about an excellent program that's a partnership of a very large employer in the Commonwealth, and a very good nonprofit community-based organization where they do training specifically to get the clients jobs with that employer. It's competitive, and there aren't enough of these programs. And there's not enough funding for these programs, but welfare recipients should really be among those who have the first shot at it. The problem is, to qualify, you have to have a high school diploma, and you have to have a basic amount of computer skills. So fortunately, the program she, on her own, reached out for qualified her for this program. She got into it, she began it, and then she hit the time limit. There's more to that, but you know, if under the bill, her situation would have been assessed, she would have been referred to programs early on and had a chance possibly to complete them within the time limit, and if not, the additional criteria added to the time limit would have allowed her to be approved.
Thank you very much.
Good afternoon. Thank you very much, Madam Chair and members of the committee. My name is Deborah Harris. I'm a staff attorney at the Massachusetts Law Reform Institute, and I thought that it might be helpful for the committee to have some background data that is relevant to the testimony that my colleagues Naomi Meyer and Melanie Malherbe have presented. So you have a little chart pack here with some background data. And the first one, which is on page 2, shows you the Massachusetts welfare caseload. And it has been going down very dramatically and precipitously. The current caseload stands in December at 35,716 TAFDC families. That compares with about 114,000 families in the early 1990s before welfare reform, a little bit more than 90,000 families at the start of welfare reform. And as you can see, it is still going down. Implicit in the testimony that you just heard are some of the reasons for that decline, although nobody has done any studies. We don't really know exactly why it's going down, and we certainly don't know what's happened to the families who are no longer getting cash assistance, although anecdotally, we know they show up in homeless shelters, they show up at DCF, they show up in other places. One reason we think for the decline is that families have not been getting extensions of the 24-month time limit. Certainly the prior administration, and we think to some extent the current administration, basically said no. Families that needed extensions were not getting extensions. No matter how much the family had tried during their 24 months of benefits to become what the administration calls self-sufficient, even though none of us is truly self-sufficient, no matter what they had done, the answer typically was no. Another reason for the decline, which I think a lot of you heard about, was a business process redesign that made it much harder for families to access benefits, and various other reasons as well that we'll talk a little bit more about in a minute. So looking at the next chart, what's the effect of this? One effect is that although the poverty level is still quite high in Massachusetts, we have 120,000 families with children in poverty. TAFDC is doing a much poorer job than it was in the early 1990s in serving families in poverty. So in the early 1990s, there was about one family receiving TFDC for every family in poverty, and now we have about 39 families receiving TFDC for every family in poverty. So the next chart shows you that for families in deep poverty, the situation is even worse. Deep poverty is about 50% of the federal poverty level. We now have more families who are below 50% of the federal poverty level than families who are receiving TAFDC. One reason for this, which is on chart number 5, is, as was mentioned earlier, that grants have not kept pace with inflation. So the grant now, the maximum grant for a family of 3 is $618 a month. That's for a family with 0 countable income. In 1988, a family was receiving in real equivalent dollars more than $1,000 a month. So with the value of the grant going down, even families that are earning tiny amounts of money or who have very small benefits from some other source are no longer eligible. And that's one reason for the decline in the caseload. Of course, the families are not better off. They're just not getting the supplemental assistance that they would qualify for if grants were slightly higher. And again, on chart number 6, the grant pays currently only about 40% of the federal poverty level. The federal poverty level is $1,674 a month for a family of 3. Our maximum grant, $618. It's pretty pathetic for a high-cost state like us. So one question relevant to all of this is, what are we spending on employment services? And on chart number 7, you can see, well, actually things are improving somewhat there. We were spending very, very little around fiscal year 2012. In 2008, it was up around $35,000. but then dropped precipitously to about 35 million, then dropped precipitously to about 7 million, and in fiscal year 2016, it's up to 16 million. The governor has proposed a significant increase overall in the employment services program. He's taking it from the wrong place. As my colleague Naomi Myers said, the governor has proposed eliminating cash assistance benefits for 6,900 families where a family member is getting SSI benefits, and drastically cutting TFDC benefits for another 1,600 families. And he proposes to redirect some of that money to the employment services program for TFDC families. Of course, the families who are losing benefits won't benefit from that at all, and most of them probably wouldn't benefit anyhow because they're severely disabled and may not be able to participate in a program in any event. So the redirection of the money, definitely the program needs more money, but the governor's proposal is not the way to go. And then looking at the next one, this is somewhat out of date because it's based on the most recent data that are available, but it gives you an idea of what percentage of federal and state welfare-related funds are spent on work supports in the New England states. Federal funds for welfare, $459.4 million in the federal welfare block grant, and another $359 million or more than that in required state maintenance of effort spending. So that's the total package, more than $800 million. We're now spending on cash assistance alone about $200 million compared to the $800 million that we were spending back in the early 90s. And this shows that of that total package of something more than $800 million, we're spending 0.58% on the employment services program in federal fiscal year 2013. It's a little bit more than that now because the spending has gone up. And then looking at the last one, what are we doing to support recipients in training or post-secondary education? Not very well compared to other states. We were the 40th of all the states in the percentage of cash assistance recipients in training or post-secondary education, even though we know that particularly in Massachusetts, that kind of educational support, that kind of training is more critical probably than anywhere else for people to be able to compete in our state. So I join with my colleagues in asking you to support this bill, which is a very, very small step in the right direction. But as my colleagues have said, we also need a whole lot more than that. We need rejection of the governor's budget proposal, and we need significant improvements to the welfare bill that was passed by the legislature in June of 2014. That bill, it had some good provisions, including some that were mentioned, such as extending the time allowed for education for post-secondary education to 24 months. But there are other things that definitely do need to be corrected, including, among others, a requirement that applicants do job search, which has not been shown anywhere to help people get into an education or training program that they need in order to be able to move forward with their lives. So thank you very much.
Thank you. Any questions? Thank you for your testimony. The final bill we have in our docket today is Senate 101.
I won't have the final one.
Oh, Senate 101, enact protecting persons who provide information to protect children. Go ahead, Laura. Can you please state your name for the record?
Yes, Lori Fortin. So I was late here. Can I weave in the other bills that I'm in support of too, or do I have to stay on this one?
You would have 5 minutes, you can go all together.
Oh, great. So my name is Lori Fortin. I'm a person with lived experience through DCF many, many years ago. And so in everything I do, I try to inform the department in the family voice. And I'm also disabled. I have a prosthetic leg, nothing, no exciting story, except I had an infection. So I'm really passionate about the causes here. So first off, and I know you already talked about the Ombudsman's office, but I'd really like to state that the Ombudsman's office within DCF is not really an Ombudsman's office. Through my work that I'm not my volunteer work that I'm not representing today, I was actually a liaison for the Ombudsman's agency, where people from our Family Advisory Committee, along with the Ombudsman's, worked together, and we started an advocacy group for the department, and little by little we were then called liaisons to work with the department, and it would work in the cases that weren't so involved, with helping families understand what DCF is all about, the rules and regulations, and that they're not the only ones involved, and helping DCF to understand where the family's coming from. So in cases that aren't as complicated, it works. But we always get confusing and complicated cases by the time it gets to the Ombudsman's office. So often that the Gordon case, I don't know if you've heard of it, but I brought copies for you, that recently the federal government and the Department of Justice made a ruling against DCF for discrimination on a parent with an intellectual disability. And that case was actually in the liaison department. So that what I believe was the best part of the Ombudsman's office, given that family perspective and voice in the table, it didn't even work, where the federal government had to come down and say this isn't the way to work. And through that case, there was so many others that were filed because of it, that the Department of Justice, for the first time ever, wrote a technical assistance about working with parents with disabilities in not only DCF but in the courts, and to help them. But it's not any better out there because there's still no accountability. So if the Ombudsman's office was outside of DCF, I do believe, once again, we can gather pretty intelligent and people that know families that have been through it before, that know the department, and to help families maneuver the system and for the best interests of the children. I'm also in support of the Kinship Act for grandparents. It baffles me, and a lot of these cases do go to the Ombudsman's office also, but the grandparents are not a party on the case, so they don't even get any support from the Ombudsman's office. But if a child had to be removed, of course family should be the first option. It is in the policies. As parent partners, we help train on the policies of the department, and that was the first time I looked. I don't know where I'm at, but to really bring home what the policies mean and why the policies are there, and if policies were followed, a lot of these cases in the media and everything, it wouldn't be. And I also really like the criteria for removal of children to be no reasonable doubt instead of reasonable cause to believe. We're all families. We all have problems. Sometimes our problems don't have to be solved with the department. I have a daughter that was unfortunately addicted to drugs, but I thank God she recovered from that. And I did have guardianship of my children. I didn't need the department. Granted, I was a little more aware because I know how the department works, and I didn't need to go to the department to go to probate court and get custody of my grandchildren. And in order for her to get better too, once she stopped using the drugs and was in recovery, she wasn't getting those grandchildren right back. It was a slow process. But in the DCF policies, I wouldn't, if I had them placed with me by DCF, which I probably wouldn't have because I had an open case way back when, but their policies don't allow for my daughter to come back into the home clean and start taking on that responsibility. And we were able to solve it. She has full custody. I'm a grandmother again. And so I think no reasonable doubt would stop the cases that and some do come for retaliation or from neighbors calling on each other or medical stuff with disagreements on doctors and cares. Those children that are really abused and really neglected and they should have alternate care so the parents can get better. I know it happens. I had to do it to my daughter. But those that just need a little supports in the home are so much better. And so the retaliation, a lot of the parents I see too, they weren't bad parents. They might have had issues and they're working on them, but once the department takes custody, it's so hard to get your children back. And then they see their children during their visits, and sometimes they have bumps and bruises. You can see in the Gordon case, she had burns and bumps, and they'll report about the foster parent, and it's discarded because they're parents and they're just mad because they don't have their kid. No, parents are pretty protective over their children. So I think this last bill to protect children from mandated, that reporters that are doing it in good faith. These parents really believe their child is not getting good treatment in some of the foster homes, and they're not. The reports that go into DCF for against foster homes, less than 1% are screened in. Yet for biological parents, it's 80% that are screened in. There can't be that much different in human nature. So that's my spiel. Would you?
I just have a comment. Have you contacted the Office of the Child Advocate? Because that is another means for you to kind of voice your concerns and have an independent authority look at them and weigh in.
Yeah, I can do that. I was involved through my volunteer work with Gail Garinger when she was, but I'm not. I was letting Maria get used to her new. Good. I will do that. Thank you.
Any other questions? Thank you very much.
Okay. Do you want these?
Sure. Seeing no one else testify on
This is
Senate
the
Bill
actual
8, I
case,
now
and this is the
declare the
technical
public
support.
hearing on children, families, and persons with disabilities hearing closed.
Senator Finnegan? Yes.
Yep.
I was just wondering, so I was looking at the introduction for the election programs, and I saw the big comments, and working on the national copies. I was just wondering. For what? Oh, sorry, for the, so I was just wondering, I saw that they were sent to the pastor house to be ordered to the house school committee, and so that we can take a look at it. So was it just like a?
I wasn't on the committee
You
before.
were on the
I have no idea.
Okay.
I was appointed the chairman of this committee this year, so
Okay.
anything that happened before wouldn't have been under my purview.
Okay, and I don't know if you can speak to just your personal opinion on these bills.
I think, yeah, we're gonna,
Calling the office?
we're gonna look at all the bills. Quite frankly, DCF bills are very complex, very involved. So it's something that needs to be scrutinized, and it'd be very difficult to comment, based on just kind of the other thing too is off the record, when you're looking at our bills, make sure you know that sometimes our bills stay in committee, but our language moves.
Okay.
So that doesn't mean our bills haven't passed.
Okay.
Like, I have an expert bill.
Yeah.
That expert bill's not gonna move, but that language is in the drug bill that I'm now debating in the
Okay.
conference committee.
Yeah,
So,
it's just I'm still learning about all this.
so just know that sometimes, because I know you were looking at it was like Lawrence or Ferguson's or something.
Yes.
The bills will sometimes just stay,
Okay.
and we'll take the language and move it someplace else.
Okay, so maybe Representative Rosa would know his language.
It hasn't, that's why it's here today.
Okay.
But I'm just saying, just so you know,
Yeah.
like my expert bill, which is a mental health and substance abuse,
Okay.
that will probably never move, technically.
Okay.
But it's in the bill that I'm doing a conference committee for.
Great. Okay.
So the language is there, but the bill's
Yeah.
not there.
Yeah. Okay.
This is Amanda, my legal counsel.
Yes, nice to meet you. I'll call the office. Thank you.
Sorry, it's just she's running really late.
Yeah, no, I totally get it.
I was just a reporter for a second.
Oh, nice to meet you. Yeah, so we'll be in touch. Okay, thank you.
Yep. Bye, Cameron. Good to see you.
Thanks, Jen. You too. Good meeting. Sitting on.
Yeah, is this your first one?
No, it's not my first one, but I'm getting better at listening. There's just a lot of things going on. But I have to go around and write this story now. But have a good rest of your day.
You too. How are you studying?
I studied journalism, college. Fine, great job. So I'll talk to you later, okay?
You too, man.
It's recording.